the delay, but here we are. So the first question is, what do we mean by solitary confinement? And this is a topic which was addressed only fairly late in the history of soft law in this area. And the most powerful definition that we have is that derived in slightly different words, but always derived from Rule 40 of the Nelson Mandela Rules, which says that solitary confinement is the confinement of a prisoner for more than 22 hours a day without meaningful human contact. Now, this is quite a narrow definition of solitary confinement in one sense, because if the person does have meaningful human contact for more than 2 hours a day, therefore, as far as the Nelson Mandela Rules is concerned, you are not dealing with solitary confinement. On the other hand, and I hope we'll come back to this, and I'd be very interested to know also from people who have practical experience, the interesting question is, what in fact do you mean by meaningful human contact? So bracket that question, think about it a little bit, and then we can come back to it. If we could go to the next slide, please. Okay. Now, before the Nelson Mandela Rules were adopted in end of 2015, 2016, the CPT, much spoken about already, an organization familiar to all of you, had done some absolutely sterling work in the area of solitary confinement. And they recognized 4 types of what they called solitary confinement. Solitary confinement could be something which was the results of the outcome of a court decision. In some countries, particularly in Scandinavia and Northern Europe, the courts tend to use this policy of saying you should keep someone in solitary confinement. Notice the slight quotes around it for a minute. The court could order it. Then, perhaps in most countries in the world still, solitary confinement can be imposed as a disciplinary sanction in a prison. Then sometimes, as practitioners would know, you tend to use solitary confinement as a preventative administrative measure or for the protection of a prisoner concerned. So preventive administrative measure, someone is a great danger, you need to protect others against that person for some period, or the prisoner comes to you and says, look, I'm greatly threatened. A very typical example would be someone convicted of a severe child sexual offense. And you say, well, the prisoner says, well, just keep me away from other prisoners because they're going to do harm to me. And that is the great strength of the work that the CPT did. I stuck the reference in very small print in the bottom, but you can find it by going to their website. From in their wonderful bottom-up, where they came and said, these are the 4 areas where we have problems with solitary confinement. And they said, solitary confinement usually means a prisoner being held on their own, but it sometimes may mean a prisoner accommodated together with another prisoner. And that's an interesting point, because when we talk about meaningful human contact, if you put 2 prisoners in a cell, or you squeeze even 3 in, and you don't let them see anyone else for a very long period, is that solitary confinement? Well, it doesn't seem to be according to the UN definition, because they have meaningful human contact, or maybe meaningless human contact. But you have that problem of 2 people in a single solitary confinement cell. But what the CPT didn't do at that stage was think in these terms of at least 2 hours, of less than 2 hours of meaningful human contact, amounting to solitary confinement. But in its further work, the CPT then went into each of these 4 types and found they were slightly different, and then came up with a marvelous mnemonic, the way of remembering this, and said, whatever type you use, if you're dealing with those 4 types of things, your intervention of keeping them away from other prisoners should be proportionate, it should be lawful, it should be accountable, it should be necessary, and it should be non-discriminatory. proportionate, lawful, accountable, necessary, and non-discriminatory. And these are really key words to alert the practitioners to the sorts of questions you should be asking about the human rights of people who you've put in solitary confinement as in one of those 4 categories. Now, we may want to come back to this in a minute, but if we could go to the next slide, please. The European prison rules approach this position differently. For the European prison rules, solitary confinement as defined, in other words, less than 2 hours of meaningful human contact a day, may only be used as a disciplinary punishment. I repeat that. It's a very narrow view in that sense. Solitary confinement, meaning less than 2 hours a day of meaningful human contact, can only be used for disciplinary offenses. And immediately you should say, well, what about all the other things? Well, the European prison rules regards administrative segregation, orders made by the court, and so on, as separation. And separation is different from solitary confinement. In what way is it different? Well, the European prison rules say that unless you're dealing with a disciplinary case, every prisoner who is separated from others must have at least those 2 hours of meaningful human contact each day. It doesn't have to be contact with other prisoners, but it does have to meet that basic requirement. And a very good example of that from the case law is one of Europe's most notorious cases, that of Anders Breivik in Norway. Breivik is kept, and I understand is still kept, in quite generous prison accommodation. He gets lots of meaningful human contact from people who come, prison officers, psychiatrists, and whatever, but he's not allowed ever to mix with other prisoners, and the European Court of Human Rights has said that's acceptable. So the crucial thing about the European prison rules is that unless you're dealing with discipline, you cannot put someone in solitary confinement in the sense that the Mandela rules use the term, you can only separate them. And while separating them, you have to deal with them as people who, in terms of the European prison rules, are subject to central biosecurity and safety measures. Separation is one example of such a measure. And if you look closely at Rule 53, and indeed Rule 53 capital A of the European Prison Rules, 53A is the very rare thing in soft law where we've actually put in a new rule halfway, and you go through them. What they say there is very much the same sorts of things that the CPT was talking about when it developed its planned set of limitations. That means if you have someone in separation for anything except discipline, in general terms, you have to do it for the minimum period. You must have the minimum restrictions which are necessary for achieving the purpose of that particular type of separation. There must be regular visits from a staff member appointed by the head of the prison, or the head of the prison, him or herself, and so on. You can look for those up yourself in Rules 53. It's actually not 4, it should be Articles 53 and 53A of the European Prison Rules. However, when it comes to solitary confinement for disciplinary purpose, as far as the European prison rules are concerned, there's more that you should know, and that's in the next slide. Okay, so the European prison rules allow for solitary confinement in the sense of less than 2 hours of meaningful human contact to be imposed as a disciplinary sanction. But having said that, the rules all in Rule 60, sub-Rule 6, try and restrict the use of solitary confinement. So the first is, which you have in front of you, it says that solitary confinement shall not be imposed as a disciplinary punishment other than exceptional cases, and then for a specified period, which shall be as short as possible and never amount to torture or inhuman or degrading treatment or punishment. And then 66D says the maximum period for which solitary confinement may be imposed shall be set in national law. Now, if you read this very carefully, you realize there's something missing. And what's missing is the European prison rules limit solitary confinement only to discipline, but they don't limit it in terms of prescribing a fixed period. So the Mandela rules said 15 days, I think. The CPT said a maximum of 14 days. The European rules don't say that. Why? Bluntly, because it wasn't possible to get the countries to agree, and one country in particular took a very firm line and said, we will never sign up to the rules if they spell out a fixed period. So that's the bad news. The good news is, from a human rights perspective, is just look carefully how 60 subsections 6C and D fit together. They say, whatever you do, it has to meet, it should never amount to torture or inhuman or degrading treatment or punishment. And secondly, it says national law, there must be a national law which says what your maximum period is. And if your country hasn't done that, they are already not doing what the European prison rules expect. So let me give you a practical example. If country X were to say, well, we can legislate what we like, we're going to legislate that anybody can be kept in solitary confinement for 6 months, 180 days. Well, in terms of 60 sub D, they can do that, but 60 sub T says solitary confinement shall never amount to inhuman or degrading treatment or punishment. And if you did have a law which said 180 days is fine, I would think that a prisoner could very easily approach the European Court of Human Rights and say, well, the limit is so long that being kept without any human contact for 23 hours out of 24 a day is a form of inhuman or degrading treatment, if not torture. And I suspect the court will then say, well, what does the psychological evidence say? What do the other standards around the world say? And country X would probably not be able to get that accepted. You would probably find an infringement of Article 3. And this is what Trina was kind enough to refer to my previous work. This is how these things fit together. And this is why in Europe, the European prison rules are so incredibly important. The European Court of Human Rights has several thousand times now referred to them when having to decide questions. Because the European Convention on Human Rights doesn't tell you what is torture, what is inhuman or degrading treatment. They've got to make sense of it. And the way they make sense of it is to go outside the framework and look at it more widely. So that's perhaps the important takeaway here. Then the other qualifications are also important. One of the problems you have with solitary confinement is you could work around it. You could say, let's say we had a fixed limit of 2 weeks, 14 days, and you could put someone in solitary for 2 weeks, allow them out for 6 hours, and then put them back again. So Rule 60, subsection 6, subsection E, is designed exactly to prevent that. And it says that where a punishment of solitary confinement is imposed for a new offense, and the prisoner has already spent the maximum period in solitary confinement, that's the maximum period the country's law prescribes, you won't implement it without first allowing that prisoner to recover properly from any adverse effects. So what am I talking about? I'm talking about a prisoner who gets put in solitary confinement, let's say for severely beating up another prisoner. And your country's law says the maximum is, I don't know, 12 days. So he gets 12 days. While he's in solitary, he manages to punch an officer as well. They say, we can't have this. We're going to give him another 12 days. Well, you can't just keep him for the 12 days and then and you can't have him then for 24 days. You have to let him out, give him a chance to recover and so on. And then there are other exceptions as well. Children, pregnant women, breastfeeding mothers, prisoners, never in prison, never in solitary confinement. And then also, I've just summarized it here for you, but a very interesting one. Prisoners whose mental health would be worsened by it. And that's quite a wide rule, because solitary confinement will worsen many prisoners' mental health. And what the European prison rules say, if you know this prisoner is going to suffer severe mental problems by putting him in solitary confinement, you're not allowed to do it. So to summarize, the European system restricts pure solitary confinement only to discipline. When it comes to separation, you've got to make sure you may still separate people, but it must not be solitary in the sense of them not having enough human contact. You can still impose it as a disciplinary offense, but there are lots of careful things that you have to do to ensure that it's not abused. Final slide. Thank you. That's my summary of these issues. There are, of course, many other issues we can discuss, and particularly that we're such a small group, I hope we can do that. Thank you very much for doing the slides. If you could just take away the shared screen on your side, and then we'll all see each other in a larger form. Okay, so those are my introductory thoughts on this. We have a good period for discussion. I'm particularly interested from hearing from colleagues who have to deal with these things in practice. Although if you're not in practice, I still want to hear from you. How do these problems arise in your system, and how do you deal with them? Now, if I were a professor and you were sitting in my class, I could point at someone and say, "Well, what do you think? I can't do this yet." So any responses that we have entirely voluntary. Brody, do we have any chats that I can't see or should be looking at?
No chats here. So if anyone has a question for Dirk, please feel free to unmute themselves.
Yeah, or if you're shy, write us a note. Who wants to start? Perhaps let's go around. I'm going to start from the bottom of the screen, people I don't know. In your country, Thomas, is there a limit on the length of solitary confinement one can have? Thomas, I'm speaking to you. Well, Ignacio, I can see you, so you must be there. Maybe he's just gone off for a break.
Sure, I am here. In my country, I'm from Spain, it's 14 days.
Exactly. So you would meet both the standards of the Mandela rules and the European ones.
Since the first law of the democracy, we've been practicing 14 days.
Okay, but now let's imagine you have someone who is being kept on their own, not as a result of a disciplinary offense, but because, I don't know, they tend to be very violent.
Sure.
Could you keep someone in solitary without them being convicted of a disciplinary offense?
It's a rare condition, but I think it's for maybe one. You have to inform to a judge, and that's it. It's the maximum. It's like the people who are in the streets. It's 72 hours.
That's very interesting. I imagine Spain is one of the systems where you have a judge who actually a penitentiary judge of some kind who makes these specific
specifically. Yes, that's
okay. And do you find a last question? I don't want to cross-examine you. A last question: do you find people getting repeated periods? Because that's also something which is often a problem.
it's rare. 14 days 14 days in a row. Then every single day your doctor is gonna visit to you and to see what your conditions are. And then if you have more more discipline concerns, you have to rest 1 or 2 days to continue the another 14 days. It's
So you do
14
have
days
that
in a
idea.
row. You have to break it the period and then continue another 14 days in that case.
Okay, no, that's very interesting. I'm just looking at my audience again. Roberta, in your country, sorry, you muted. You just need to unmute yourself.
Okay. Hello to everybody. In my country, in Italy, we have three kinds of solitary confinement. The first one is for sanitary medical reason, and it depends from the decision that is made by the doctor. And then we have the disciplinary confinement, and this is maximum 15 days.
15.
But in these 15 days, it is mandatory that he has to go to the country yards 2 hours a day. And then we have the judicial confinement, and it depends from the magistrate decision.
Right. That's all very interesting. Two questions I want to ask.
Yeah.
The one is, if the magistrate makes a decision, is he also limited, or she also limited to 14, 15 days?
No, it could be longer. It could be longer.
Yeah.
It depends from the investigation period, and so it could be longer than 15 days.
Because that raises a very interesting legal question. When we were drafting these changes to the European prison rules, one of the problems we had was areas of competence. You know, we tend to be looking at it now from the point of view of prisoners or people who run prisons. But of course, the judge comes from the outside, and there was a legal question: could we make a rule, the Council of Europe rule, that would compel the judges, as it were, also to obey the same limits? And I remember a lot of countries raising this problem, and I don't think we ever resolved it. And in the end, I'll be honest, I thought, well, let's just leave it. Let's just put it in as it is. Because if you were to get a problem like that, it would be very interesting. Let's say in your country, a judge orders somebody to be held in solitary confinement for 60 days. And that prisoner could again then go to the European Court of Human Rights and say, the judge has ordered me to be held all on my own for 60 days. That seems quite a lot, given that the scientific consensus now is that after 2 weeks, it may do somebody severe harm. So we haven't had, I'm not aware of us having had a case like that. There are a few old cases. There's a case called Rode versus Denmark, or the most famous one of all, Sanctions in France, who was for older people, Carlos the Jackal, who was the great, one of the best known terrorists, I suppose, of his generation. And he was kept in solitary confinement for, longer than a year. But in that time, he had incredible number of visits, and he married his lawyer.
Okay.
So and the court said, in these exceptional circumstances, it's probably okay. So we haven't really had these things tested since the laws changed in those areas. But thank you. Those were very interesting comments. Can I ask either you, Roberto, or anybody else? I'm always trying to involve as many people as I can. Do you have examples of providing meaningful human contact? Because what do we really mean by meaningful human contact? Is that an issue which is who? Come on, be honest. Who's not from either Spain or Italy in our little audience? Anyone? Johanna, are you from one of these? You're smiling. Yes.
Yeah, I'm smiling because there has been a while that I haven't spoken any English. If I'm from Finland.
You're doing very well. Go for it.
Yeah, a bit nervous. Our placement in solitary confinement is for maximum 10 days. And what I think about meaningful, what would be meaningful to me would be when somebody would speak to me and even smile and have some kind of other contact than just people walking past me.
Yeah, it's a very, very difficult test to apply. And I know at the moment, it's not something I'm working on myself, but I know at the moment the Council of Europe is looking at rules relating to artificial intelligence in very general terms, the use of technology and so on in prisons. And one of the things they're grappling with is if someone is kept in solitary, but they can have an hour's video contact, is that meaningful human contact? I suppose it depends, but it's not what was originally thought about. I mean, there are those difficulties. And the other question is, let's say you have a guard who brings the food to the prisoner. Does that count? Well, if he stops and, as you were saying, Johanna, and he has a good chat, that could count. And if he just puts it in a hatch through the door, that presumably doesn't count. So this is a very difficult concept to apply in practice. And the CPT is beginning to try, and since this idea of meaningful human contact has gone through, the CPT has been beginning to try and make sense of it, but it's still very limited the extent to which it can. Yeah. I'm just trying to see who else has had experience of having to deal with this at all. I just see names in front of me. There's one name that simply fascinates me. It's just a one word, Appleton. Who is the person behind it there? No response. Right. Are there other questions that we need to address? We do still have a significant period of time. Yeah, perhaps just one. Yeah, sure. Sorry.
Maybe I can just mention. Just a second, because now it's better. So my background is in the German prison administration, and there it was possible, so as well, the 72 hours. But at the same time, when someone was very violent or like there was a danger of suicide or whatever, there's always like a reason, I think in the law, it depends on the federal state, to keep someone longer. So when you look into the media, there are different cases where, especially in pre-trial, people were held over months and weeks and years even. So I guess that's everywhere. They have these cases when someone is a very, let's say, offender, media and the whole known in the media, for example, then it's very difficult. You mentioned the one case from Norway, but I guess there are several more in different countries, and often the 1 hour, so 1 hour in the yard, and even when staff was there, I think that maybe they counted already as the human contact, although it's not really. So yeah, that's the situation.
Thank you. That's very useful. I mean, a number of things out of that. The first is that a lot of these problems arise at a pre-trial stage, and cultures differ spectacularly here. So countries which tend to be very liberal, have very high prison standards, Scandinavian countries in particular, seem to be the countries that use a lot of solitary for people who are at the awaiting trial stage, the pre-trial stage. And the question is, how can you deal with that? And one of the answers seems to me to be that you can deal with it by not removing the human contact, but by deciding carefully who should have the contact with them, and then make sure that they get that. Because nobody says that prisoners can choose their contact. So let's say you have someone who's being held pre-trial, and the judge's big concern, maybe entirely legitimate concern, is this guy is part of organized crime gang, and there's a risk that he will tell the people that he has contact with, you go out and deal with the witnesses, or you go out and do something like that. In which case, it doesn't mean you should abandon the rule about meaningful contact, but it does mean you should think carefully with whom they have meaningful contact. And that's why I find the Breivik example so interesting, because it is truly the most extreme case. It's someone who committed scores of murders, and the country was determined not to depart from the standards. So the way they did it was to give him super nice cell, lots of accommodation, all the books he wants, so on and so forth, but no contact with other prisoners, because the fear there was that the prisoner, political influence of others. But less known people may end up just being forgotten, really. That's one of the concerns. Another very interesting thing that Roberta said, which we need to unpack a little bit, is solitary confinement on medical grounds. Now this became particularly interesting during the HIV AIDS problem period, and indeed with the German colleague Professor Frieda Dünkel and I edited a book on solitary confinement, on what happened in prisons as a result of COVID, and then also other diseases. And again, the same is true. It is possible a system sensitive to human rights would try and think carefully. If the doctor orders someone to be isolated, does that mean they have no contact anymore? I mean, to take a biblical example, if they have leprosy, you still find this in parts of Africa, do they have no contact at all? And the answer to that must be, well, clearly they can't have contact with anybody they can communicate the disease with, but you've got to try and think about other ways in which they have the advantage of some form of contact. And of course, excuse me, another thing which is worth emphasizing is all these rules are in some senses arbitrary. So we've got to make a decision, 14 days, 15 days, or whatever. And that's what we were trying to force countries to do by saying there must be national legislation. And in the people from different countries have spoken, there is national legislation, but it's not true everywhere. But the psychological effects may vary. I mean, you have fantastic examples of people surviving solitary confinement, and you have other people who literally crack within 2 days. So one has to think, the law can only do this much. The law can set the outside boundaries. But ultimately, and this sounds a bit like preachy, I know, but ultimately the human rights element consists of making sure that everybody there is treated in a humane way. And people I've interviewed who've worked in this area all say, if you work in that area, you get a sense of who is capable of coping with further detention. And it's important also to emphasize the rules set maxima, and they set other provisions that everybody should be visited by a doctor once a day or whatever. But these are formal guarantees. There's a sort of a human element to this whole thing as well. Okay, so there the German example is a very good one. One other thing that came up in the general discussion that interested me was somebody said, I think it was Trina, that the European prison rules apply also to people who are not prisoners in the ordinary sense that we understand it. That's not quite true, actually. The prison rules were designed to deal with prisons for sentenced and unsentenced people, adults actually, sentenced and unsentenced adults, and unsentenced in the sense of being awaiting trial. And others are covered only if they happen to be in a prison for which this is the primary purpose. So if you have a center for the detention of asylum seekers, and it's not a prison, it's a camp of some kind or another, it's not obvious that the European prison rules apply, but it is obvious that the broader human rights standards apply. So you can't treat people like that, even if you think they are, heavy quotation marks, terrorists. You can't treat people in those things contrary to the broad standards. And in that respect, the Mandela rules go slightly further, because right at the end of the Mandela rules, there's a provision which says all these rules would apply to other people in detention as well. But it is worth thinking about that. And of course, from the slightly narrow perspective of, excuse me, of Europris, that's not a problem, because your primary brief is to deal with prisons in the conventional sense, but it's also worth thinking about slightly more widely in that way. Okay, other questions, other thoughts? Yeah.
Maybe from those who are muted and have their video not on, it would be also interesting to hear from those instead of just listening in.
Instead of those showing the face. I try, well, we can only ask. Volunteers from the faceless ones. I'm simply going to go through Proca Florin. Anyone else? You know what this feels like? Is but Brody, you flashed on and off. Any insights from the Europris side? Think that we should still come. Ah, there's someone. Apazak. Light went on, but still no person. Hello. Yes. Hello.
Hola.
Ah, yes, we can hear you, and we can see a sort of gray background. That's fine.
Hola.
She's talking about the.
Bueno, ya.
Yeah.
Gracias. Thank
Okay,
you.
Thank you. And my
Osondo. Osondo. Gure herrian. Euskal Herrian.
En español, en vasco creo que todavía peor.
Bueno.
She's talking about it's very hard, the confinement period. We work in the same place. We work in Vitoria, in the north of Spain. And she's talking about it's very hard for one person to do the solitary treatment and the confinement and the very long sentences she's complaining about. I think it's a max mix of things, you know. But in the real
world
center, in the real center of the things, because I think the human treatment in prison is the key, and it's for that in my experience, 24 years in prison, I didn't see the rule as it applies, as it is writing. I don't, my English is very rusty, but the rule is 14 days in a row, 2 hours in solitary in the year. In 24 years, I've never seen that, you know, because it's in Spain, it's in the very same cell you are living. It's in the very same cell. You don't change your cell to do the solitary confinement. It's in the very same.
I understand.
And then you have to make your 3 meals a day, always with the guards, with the guards and another interns, and then you have 2 hours on the yard that the rule says is a solitary, but the truth is never in solitary because the yard, all the windows from the other the cells, it's very allowed to chat, to don't know. It's quite laxus, I think. I saw this. So don't know. Maybe in another prisons it's another way, but in 4 prisons I've been, it's always the same. I understand it's a hard condition to be in solitary, but I know in Spain it's quite laxus.
Okay, well, thank you very much for that. Thanks. I apologize for not having a wide linguistic range, but I think we have had a good discussion. Thank you for